When people hear the words estate planning, they often imagine something reserved for the wealthy, the kind of thing only millionaires need to worry about. But here's the truth. Estate planning is for everyone. Whether you own a small home, have savings in the bank, or simply want to make sure your family is cared for, estate planning is about protecting your future and ensuring your wishes are respected. And when we talk about legal and law basics in estate planning, we're really talking about the foundation of security, your rights, your responsibilities, and the tools available to safeguard what matters most. Let's start with a hook. Imagine this scenario. You've worked hard your entire life, built up savings, maybe purchased a home, and you want to leave it to your children. But without a proper estate plan, the law decides how your assets are distributed. That means your family could face delays, disputes, and even unexpected taxes. The contrast is clear. With no plan, you lose control. With a plan, you take charge of your legacy. Estate planning begins with one of the most basic legal documents: the will. A will is your written instruction about how your property should be distributed after your death. Without a will, the state applies intestate succession laws, which may not align with your wishes. For example, if you wanted to leave a portion of your estate to a close friend or a charity, intestate laws won't allow it. The will is your voice, ensuring your intentions are honored. But a will is just the starting point. Another critical tool is the trust. Trusts allow you to transfer assets to beneficiaries while avoiding probate, the court process that validates a will. Probate can be lengthy, expensive, and public. A trust, on the other hand, is private, efficient, and often more flexible. Here's the contrast framing. Probate exposes your estate to delays and costs, while a trust streamlines the process and protects privacy. Smooth transition here. Estate planning isn't just about what happens after death, it's also about protecting yourself during life. That's where powers of attorney come in. A durable power of attorney allows someone you trust to make financial decisions on your behalf if you become incapacitated. Without it, your family may have to go to court to gain authority, which can be stressful and time-consuming. Similarly, a healthcare power of attorney ensures that medical decisions are made according to your values, not left to guesswork. Another essential document is the living will, sometimes called an advance directive. This outlines your preferences for medical treatment if you're unable to communicate. Do you want life support in certain situations? Do you prefer comfort care only? These are deeply personal choices, and a living will ensures they're respected. The contrast here is powerful. Without a living will, doctors and family members may disagree, leading to conflict. With one, your wishes guide the process. Now let's talk about guardianship. If you have minor children, estate planning allows you to designate a guardian. Without this, the court decides who will raise your children, and it may not be the person you would have chosen. By naming a guardian in your will, you protect your children's future and provide clarity during a difficult time. Estate planning also involves financial considerations. Taxes can erode the value of your estate if not managed properly. Tools like trusts, gifting strategies, and beneficiary designations can minimize tax burdens. For example, naming beneficiaries directly on retirement accounts or life insurance policies allows those assets to pass outside of probate, saving time and money. Smooth transition. Estate planning is not a one-time task. Life changes, marriage, divorce, children, new property, or business ventures require updates to your plan. A will written 20 years ago may no longer reflect your current situation. Regular reviews ensure your plan stays aligned with your goals. Consumer rights play a role here too. You have the right to clear explanations from your attorney or advisor. You have the right to privacy in your estate documents. And you have the right to challenge unfair practices if someone mishandles your estate. Just as with insurance, knowledge of your rights transforms you from a passive participant into an empowered planner. Let's bring in a practical example. Suppose you own a home worth $200,000, have $50,000 in savings, and want to leave everything to your two children. Without a plan, the estate goes through probate, which could take months and cost thousands in fees. With a simple trust and updated beneficiary designations, your children could receive the assets quickly, privately, and with minimal expense. The difference is not theoretical, it's real, tangible, and impactful. Estate planning also protects against disputes. Families often fight over inheritance, even when the assets are modest. Clear documents reduce the risk of conflict. By stating your intentions in writing, you remove ambiguity and prevent misunderstandings. Finally, estate planning is about peace of mind. It's not just about money or property, it's about values, relationships, and legacy. It's about knowing that your loved ones will be cared for, that your wishes will be respected, and that your hard work will continue to benefit those you care about. Estate planning is often described as a roadmap, and like any good roadmap, it doesn't just tell you where you're going, it shows you how to get there smoothly. Once you've established the basics like wills, trusts, and powers of attorney, the next step is understanding how these pieces interact with the law and with your personal circumstances. This is where estate planning becomes more than paperwork. It becomes strategy. One of the most overlooked aspects of estate planning is beneficiary designations. Retirement accounts, life insurance policies, and even certain bank accounts allow you to name beneficiaries directly. These designations override what's written in your will. That means if your will says one thing, but your beneficiary form says another, the beneficiary form wins. The contrast here is striking. A single outdated form can undo years of careful planning. That's why reviewing and updating beneficiary designations regularly is essential. Another smooth transition. Let's talk about probate. Probate is the court process that validates a will and oversees the distribution of assets. While it serves an important legal function, it can also be slow, costly, and public. Families often find themselves waiting months, sometimes years, for probate to conclude. The alternative is planning ahead with tools like living trusts, joint ownership, and payable on death accounts. These strategies bypass probate, saving time and preserving privacy. The difference between going through probate and avoiding it is not just convenience, it's peace of mind for your loved ones. Estate planning also intersects with business ownership. If you own a business, what happens to it when you're gone? Without a succession plan, your business could collapse, leaving employees and family members in uncertainty. With a clear plan, whether it's transferring ownership to a partner, selling the business, or passing it to heirs, you ensure continuity. This is where legal basics meet practical foresight. Taxes are another critical factor. Estate taxes, inheritance taxes, and capital gains can significantly reduce the value of what you leave behind. But with proper planning, you can minimize these burdens. Trust, charitable donations, and lifetime gifting are all strategies that reduce taxable estates. The contrast framing here is simple. Without planning, taxes take a larger share. With planning, more of your wealth goes to the people and causes you care about. Smooth transition. Estate planning isn't just about assets, it's about values. Many people use their estate plans to support charities, fund scholarships, or create legacies that reflect their beliefs. This is where law becomes personal. By including charitable trusts or bequests, you extend your impact beyond your lifetime. Finally, estate planning is about communication. Documents are powerful, but conversations are equally important. Talking to your family about your wishes reduces confusion and conflict. It ensures that when the time comes, your loved ones understand not just what the documents say, but why you made those choices. So, estate planning basics are not complicated when broken down. Wills, trust, powers of attorney, living wills, guardianship, beneficiary designations, probate avoidance, tax strategies, and communication. Together, they form a complete plan that protects your assets, honors your values, and secures your family's future. If this video helped you understand the basics of estate planning and how the law protects your legacy, then take the next step. Hit that like button to support content that empowers you. Share this video with friends or family who need clarity about their future. And don't forget to subscribe to the channel so you never miss practical guides that make complex legal topics simple and actionable.